Welcome to Criminal Law Video Presentation number 11. This presentation will discuss conspiracy. At common law, conspiracy was an agreement between two or more persons to accomplish a criminal or unlawful purpose, or a lawful purpose by unlawful means, with the intent to enter into the agreement and the intent to achieve the objective of the agreement. And in some jurisdictions, the conspiracy also required that there be some overt act. In some jurisdictions, no overt act was required. Where an overt act was required, it could be almost anything that is done in furtherance of the conspiracy. Go and get another conspirator. Go and get the plans to rob the bank. Go and get a car. Just about anything that is in furtherance of the conspiracy will be an overt act. So, we have to have an agreement, and that agreement has to be the typical meeting of the minds. But it does not have to be very explicit. A nod, a wink, a yes may be sufficient for the agreement. So let's see, we have our two folks here, and the guy with the glasses on is thinking, I intend to agree and I intend to complete the crime. Will you work with me to kill my professor? The guy with the hat on intends to agree and intends to complete the crime. I agree to do that. So what we have here is we have a completed agreement, we have the intent to agree, and the intent to complete the crime between these two folks. This is a completed conspiracy. You have an agreement between two or more people to commit a criminal offense. They each intend to agree and they each intend to complete the crime. So, as I said, it has to be between, at common law, two or more persons. Each person to the agreement must have the intent to agree and the intent to commit the target offense. There is no conspiracy if, for example, some of the things I've listed here, one of them is feigning agreement, one of them is an undercover policeman, one isn't capable of agreeing, they're a protected class, the crime takes two to commit. But if there's a third person with any of these, then there would be a conspiracy. So again, our two folks here, and each has to agree and each has to intend to commit the offense. I intend to agree, I intend to complete the crime. Will you work with me to kill my professor? I agree to do that. But the guy with the hat on is thinking, I'm a police officer, I intend to agree with you, but I do not intend to complete the crime. Therefore, we have no conspiracy. Again, at common law conspiracy, you had to have two intents. There had to be an intent to agree, and there had to be an intent to achieve the objective offense, the objective of the agreement, the target crime. Therefore, at common law, conspiracy was a specific intent crime, and there was no conspiracy to commit unintended crimes. You couldn't conspire to commit a crime recklessly because you needed these dual intents. So, for example, you could have a conspiracy to commit arson. Two guys plan to and agree to burn down a building, and then they go ahead and commit the arson, and during the arson people die. You could not have a conspiracy to commit reckless murder or felony murder because of the need for the specific intent for the crime. Let's look at the Model Penal Code now as a variation on this. A person is guilty of conspiracy with another person or persons to commit a crime if, with the purpose of promoting or facilitating its commission, he agrees with such other person or persons that they will engage in conduct that constitutes such a crime, or agrees to aid in the planning, commission, attempt, or solicitation to commit such a crime. Now we're going to see each of these has a significance. As indicated before, the common law conspiracy needed two or more to commit. The model penal code takes a different approach. You notice the model penal code says a person is guilty of conspiracy, and then goes on, if he agrees. The defendant agreed with another to commit the crime. This means that under the model penal code approach, a single person can be guilty of conspiracy even though the other is incapable of conspiring, doesn't want to conspire, doesn't have any purpose to promote or facilitate. The defendant will be guilty even if the other is, again, feigning, is an undercover police officer, not capable of agreeing, or a protected class who the crime is intended to protect. So, our two fellows again, the guy with the glasses, I intend to agree, I intend to complete the crime. Will you work with me to kill my professor? I agree to do that. But the other guy with the baseball hat is thinking, I'm a police officer. I do intend to agree, but I do not intend to complete the crime. This is a completed conspiracy under the model penal code, whereas at common law, this would not be a conspiracy. But because the model penal code takes the unilateral approach, you can have one person guilty of a conspiracy. Now, the culpability required for model penal code conspiracy is with the purpose of promoting or facilitating its commission. This means that the defendant must have the conscious object to bring about the prohibited result or to cause the prohibited conduct to occur. Whatever the result is for the target offense or whatever the conduct is required for the target offense, it must be the conspirator's conscious object to bring that about. Okay, let's take a look at some special issues that need to be discussed with regards to conspiracy. The first of these is what's known as the Whorton Rule. In this, if the crime needs two to complete, there can be no conspiracy to complete that crime. But if a third person is then part of this agreement, then you can have a conspiracy. So what are some of these examples? You need two people to commit adultery by its very nature. You need two people to engage in a duel. You need two people for the sale of contraband, obviously the seller and the buyer. You need two people for receipt of a bribe, the person offering the bribe and the person taking the bribe. So in each of these instances, the two adulterers, the two duelers, would not be guilty of conspiracy. It would require that a third person come in and agree to be part of committing this crime in order for there to be a conspiracy. The model penal code rejects the Whorton Rule. It basically has nothing to do with it, and you can have, where a crime requires two people, you can have a conspiracy to commit that crime. Now, this merger doctrine we're going to talk about next. At common law, conspiracy did not merge with the target offense. You could have a conviction for conspiracy and for the target offense. So two people agree, are two hapless fellows who have agreed to kill the professor, and the one with the hat goes ahead and kills the professor. They can both be charged with conspiracy to commit murder, and they could both be charged with murder, the target offense. The model penal code, on the other hand, merges conspiracy with the target offense. You can charge both, but cannot convict of both. And Ohio follows this merger of offenses. So again, with our two hapless fellows, they could conspire to commit murder, but once the murder has been committed, they could be charged with conspiracy to commit murder and murder, but the jury would be told that they can only convict of one. They cannot convict of conspiracy and murder. Okay, at common law, conspirators are liable for crimes committed. All other crimes committed in furtherance of the conspiracy and that are the natural and probable consequence of the conspiracy, that is, that are foreseeable from the conspiracy. This is what occurs when you read the Pinkerton case, where the two brothers conspired to produce whiskey in violation of the tax laws, and even though one of the brothers, once they started committing the target offense, was in jail and therefore could not do that target offense, the brother in jail was still responsible for the crimes committed in furtherance of the conspiracy, that is, the actual production of the alcohol without a license. And so an example, another example, conspiracy. You have two folks who conspire to commit a bank robbery, and one of them goes out and steals a getaway car. The other one goes into the bank and shoots the teller. And while they're in there, they take another teller into the back room and he rapes her and then runs out of the bank, and then they're caught. They could be charged with conspiracy to commit robbery, and both of them would be guilty of the actual bank robbery, stealing of the car, and shooting of the teller, because those would all be in furtherance of the conspiracy and would be natural and probable consequences. In all likelihood, the robber that rapes the teller would not be, that rape would not be attached to the other conspirator, because it was not committed in furtherance of the conspiracy to commit bank robbery, and obviously isn't a natural and probable consequence of conspiring to commit bank robbery. Okay, the next issue we're going to talk about is withdrawal. At common law, you could not withdraw from a conspiracy. Once all the elements of the conspiracy were met, the crime of conspiracy was completed. So at that point on, the conspirator is guilty of, all the conspirators are guilty of conspiracy, even if they attempt to withdraw. However, because of this natural and probable consequence doctrine, the withdrawal can limit further liability if one of the conspirators performs an affirmative act that notifies all members of the conspiracy, and the notice is given at a time when they can abandon their plans. Then the withdrawal will limit further liability for acts that are done in furtherance of the conspiracy. So it can limit further criminal liability, but it will not preclude a conviction for conspiracy. The Model Penal Code does permit withdrawal from the conspiracy, and what it does is it creates the withdrawal from a conspiracy as an affirmative defense, meaning that the defendant must raise this defense and prove it by a preponderance of the evidence. And it requires that the conspirator renounce their criminal purpose and thwart the success of the conspiracy under circumstances demonstrating a complete and voluntary renunciation of her criminal intent. If this is accomplished, then the person who is withdrawing will not be guilty of conspiracy. This is consistent with the Model Penal Codes trying to limit folks, or permitting folks, to disengage from criminal conduct to limit the criminality of what they are doing. This concludes this brief video session on conspiracy. As usual, you will need to go to the Twin site and take the assessment for video presentation number 11, Conspiracy. Thank you.